Hello, good morning, and welcome to Byju's Exam Prep. First up, we will discuss one topic which we have not covered previously. Then we will look at previous year's question papers. Then we will discuss what are the topics that you need to cover and skip from N. Lakshmikant. And then you have shared a list of questions with us. I'll take a look at these questions one by one and answer. Clear? Pardoning powers available with the President under Article 72, available with the Governor under Article 161 of the Constitution. First, I'll tell you what do we mean by pardon. Then I will tell you why pardoning power is available with the President and the Governor, and what are the rules for that. Will there be a judicial review? What are the Supreme Court judgments on this matter? And what happened recently in the Tamil Nadu case? All that in the next half an hour. Listen to me patiently. There is something called pardon, and then commutation, then respite, remission, reprieve. You have committed a crime. The district court says you are guilty. You hang by your neck till death. You appealed before the High Court. High Court said you are guilty. Death sentence. Appealed before the Supreme Court. Supreme Court said you are guilty. Death sentence. Filed a review petition. Dismissed. Filed a curative petition. Dismissed. Is there any other alternative available with you? Yes. What is it that you can do? You can file a mercy petition before the President or the Governor of a state. President of India, the Governor of a state where you have committed this crime. And what are the options available with the Governor? What are the options available with the President? The President can pardon you. What do we mean by pardon? Not only will you be set free, you will be free from all disqualifications. Free from all disqualifications. What does that mean? Shri Rahul Gandhi was convicted by the Gujarat High Court for criminal defamation. For that, he was sentenced to jail for 2 years. He will have to stay 2 years in jail, provided Supreme Court also upholds this verdict of the Gujarat High Court and gives the same punishment of 2 years. Which means Rahul Gandhi will have to stay in jail for 2 years. As well as, once he is released from jail, for the next 6 years, he cannot contest elections. But if he approaches the President of India and President pardons Rahul Gandhi, not only will Rahul Gandhi walk away from jail, that means he won't be serving 2 years in jail, he will also be free from all the disqualifications that exist because of that conviction. Because of that conviction, you could not contest election 6 years after the release. The President will say you are pardoned. Not only will you not remain in jail, stay in jail, you are free from all the disqualifications. It is as if you are born out of the womb of the mother today. That is pardon. Why this power is given to the President, we will discuss slightly later. But this is what pardon is. If not pardon, President can commute. What do we mean by commutation? Replacing a punishment with a lesser punishment. Or should we say next lesser punishment? You committed a crime, High Court, District Court, Supreme Court says death sentence. Review petition dismissed, curative petition dismissed. You file a mercy petition before the President. If the President commutes your sentence, which means your punishment will be replaced by 1 degree lesser punishment. If you were given death, it will be replaced by life imprisonment. If you were given life imprisonment, it will be replaced by 14 years in jail. If you were given 14 years in jail, you may be given 10 years in jail. That means you are being commuted of your sentence. Your sentence which has been awarded to you is replaced by 1 degree lesser. And primarily it is used to, when a death sentence is given to an individual, that death sentence is reduced to life imprisonment. That is what we call commutation. You're not pardoned, your sentence has been commuted, which means you will not be set free, but your sentence has been reduced, which means there are still disqualifications. Clear? Or respite. For example, medical condition of a convict. Convict is a pregnant woman, or convict is suffering from some disability. That doesn't mean you will not be punished. That doesn't mean people with disability or pregnant women, they can commit crimes and get away with that. You will still be punished. But for your medical condition, you will be given respite. Scorching heat in Delhi. People in Delhi got respite from the scorching heat because there were showers. Unexpected rain. So you are getting respite from the condition that you are in right now. That's what we call respite. So the President, what he can do, can reduce the sentence, can change the character of the sentence as well. What does that mean? This pregnant woman committed a crime for which she was given 5 years in jail, but 5 years of rigorous imprisonment. If she approaches the President, President can grant her respite because of her medical condition, which means not only will the sentence be reduced, let's say from 5 years to 3 years, but even the character of the sentence will change. Character was rigorous imprisonment. Now this rigorous imprisonment will become simple imprisonment. Simple. Respite because of your medical condition. If not respite, the President may grant you remission. And what is remission? Reduced sentence without altering the character. What if, for example, an individual was given 5 years of imprisonment, but rigorous imprisonment? His sentence can be remitted. Remission can take place. Sentence will be reduced from 5 years to 3 years, for example, but character will remain the same. If it was rigorous imprisonment previously, it will remain rigorous imprisonment. Or it can be reprieve. Reprieve is basically temporary stay on death sentence. For example, I have been convicted by the court. Now the Supreme Court says you are guilty, death sentence. Review petition dismissed, curative petition dismissed. Now I have to file a mercy petition before the President. And this mercy petition, when I file, first I have to accept my guilt. I'm sorry for what I've done. But I can be a changed man. I can be an asset to the society. These are the circumstances under which I committed this crime. And these are the reasons why you should not sentence me to death, why you should commute by death sentence, or pardon me, or grant me remission, or respite. So if the President grants you reprieve, that means there will be temporary stay on your death sentence till you file a mercy petition. That is what we call a reprieve. For example, World Cup is ongoing. Rohit Sharma nicks a ball, and in the slip, the catch drops. Rohit Sharma granted reprieve. That means this is temporary. Rohit Sharma will get out, unfortunately, because that's how it is. It's very rare that he will stay not out. Even his 264, he got out on the second last ball, I think. Reprieve, temporary stay. Which means under Article 161 of the Constitution, under Article 72 of the Constitution, governor and the president, they have the power called pardoning powers or judicial powers. Pardon, commutation, remission, respite, reprieve. These are the 5 set of pardoning powers that are available with the president and the governor. But all these powers are to be exercised only on the advice of Union Cabinet. Only on the advice of the Union Cabinet, because president or the governor does not have discretionary powers on this matter. Which means when a mercy petition is filed before the President of India, President will refer this matter to the Union Cabinet. Tell me what is it that I have to do on this matter. And whatever advice is given by the Council, by the Cabinet to the President is bound by that advice. But the President or the convict cannot insist on oral hearing. Which means when I'm filing a mercy petition before the President, I cannot insist that the President should give me audience. I can personally visit the President and explain the reason why he should grant me pardon. That's not a right available to the convict. Once this power is exercised, there can be judicial review on the grounds of malafide. Which means if the president has exercised power with bad faith on the advice of the Union Cabinet, judiciary can review the pardoning power of the president. Similarly, can use power to change the sentence and take evidence and take a different view. President, while exercising this power, may ask the evidence to be placed in front of him. On what evidence was this individual convicted? And basis this evidence, he may take a different view, completely different view from that of the court, and say, no, you are not guilty. We are setting you free. You are pardoned. But why these powers are available with the president or the governor? For that, we need to first understand what is the difference between the pardoning powers of the president under Article 72 and pardoning powers of the governor under Article 161. President's pardoning power extends throughout India, which means no matter where I have committed this crime, I can approach the President of India. But the governor's pardoning power extends within the state, which means if I have committed a crime in Tamil Nadu, to grant me pardon or reprieve or respite, whatever it is, I can only approach the governor of Tamil Nadu. I cannot approach the governor of Andhra Pradesh because I've committed the crime in Tamil Nadu. Which means the president's pardoning power extends throughout the territory of India. Governor's pardoning power extends only within the state. Only president can pardon death sentence. Governor cannot pardon a death sentence. But sir, recently there was a news related to Tamil Nadu that now governor can pardon a death sentence. That is misleading. That is untrue. I will tell you what is the real picture. But what governor can do, the governor can commute a death sentence. And you know the difference between pardon and commutation. Only the president has the power to pardon a convict who has been sentenced to death. Governor cannot pardon this individual. But what governor can do, governor can commute that death sentence. And only president can pardon a person from the army who has been convicted under court martial. Governor cannot. Governor does not have this power to grant pardon to somebody who has been convicted in a court martial. That is the difference between the president and the governor. But what is the Tamil Nadu case? Can governor pardon a death sentence? Because if you Google search, governor can now pardon death sentence, you will see all newspapers will be publishing this news item. Governor can now pardon death sentence, but that is not correct. Why? First, you need to understand why this power has been given to the president or the governor. And listen to me carefully. Under Article 72, president has these powers. Under Article 161, governor has these powers. But these are not discretionary powers. They have to exercise this power only on the advice of the Union Cabinet. Clear? What are these powers? Pardon, commutation, respite, reprieve, remission. Clear? What's the difference between the two? Only president can pardon a death sentence, governor cannot. President's pardoning power extends throughout the territory of India. Governors extend only within that state. Only president can grant pardoning powers, can use pardoning powers for somebody who has been convicted in a court martial, whereas the governor cannot. But why these powers have been given to the president or the governor? One, to correct a judgment which is harsh. For example, Rahul Gandhi was convicted by a court in Surat on criminal defamation. First, let me be on the side of Mr. Rahul Gandhi. It should not come under criminal defamation. That's my take on this matter. Because if you're saying, why are all Modi's thieves, or why are all thieves with the surname Modi? You are not defaming an entire class. That's not the point here. And the petitioner who approached the Surat court, it is argued in various newspaper reports that his class is not Modi. So how can you approach the court and claim that I have been defamed? Because an individual cannot be looked into as a class. So I disagree with this judgment. But even if he was convicted, let's assume he did defame. But did he deserve a 2-year punishment? Why not? 2 years is the maximum punishment under criminal defamation. Maximum punishment. So whenever you commit a crime, or whenever this accused is brought before the court, if the court declares you guilty, but the court does not always give you the maximum punishment, because I will look at your background. It's not that you are from Gandhi family or your mother is Sonia Gandhi, that is your background. No, the background is you have never been a criminal. The background is, even if you're convicted today, this is going to be your first conviction. That means it's going to be your first crime. And you are the representative of the people. If we give you maximum punishment, what will happen to those voters who voted for you in Wayanad? Because the moment I give you maximum punishment, you are disqualified, which means 2 years or more punishment, you are disqualified. So I may not give you maximum punishment. I will give you 6 months punishment or 1 year punishment, but not 2 years. But what if Surat court says, no, you are guilty, maximum punishment is awarded to you? I think it is harsh. Matter went to the Gujarat High Court. Gujarat High Court said the same thing. I think it is harsh. What if Supreme Court also says the same thing? I think it is harsh. Mr. Rahul Gandhi can approach the president. The president will look at this case on the advice of the cabinet and ultimately decide, no, this is a harsh judgment. We are pardoning you, or we are commuting your sentence. Although it may not happen in Rahul Gandhi's case, because when this matter would be presented before President Murmu, she would say, but your party did not vote for me. Or even if you voted, but see, my dear, you are very sweet, but I cannot help you because I have to send this matter to, you know who? Home Minister. Home Minister will organize a cabinet meeting. There they will discuss, and whatever advice they give me, that is binding on me. So my child, I cannot help you here. But forget about Rahul Gandhi. There is someone else who was given harsh sentence by the judiciary. The power is given to the president or the governor to correct this harsh judgment. That's reason number one. Reason number two, we have terrorism in Jammu and Kashmir, separatism. There are various organizations who want Jammu and Kashmir to merge with Pakistan or to stay independent. Some organizations, they don't want to be part of India. But that is what diplomacy is. You have to convince those who don't want to be part of you so that they can also be part of you. They want to be part of you. This is where it involves give and take. And this has been happening repeatedly. In Punjab also, there was insurgency. In Northeast, there is insurgency. What if, for example, let's skip Jammu and Kashmir, take a look at Nagaland. There are various organizations who do not want to be part of India. NSC, IN, for example, Muthaba faction. So many insurgent groups in Nagaland. You will discuss that in internal security. What if, and there was also reports a few years ago which said, finally, we have a Nagaland accord. Finally, we have a solution to this problem in Nagaland. And some newspaper reports said, maybe Nagaland will have a separate flag. Maybe Nagaland will have a separate constitution. What exactly is that accord? We don't know. Nobody knows. That's the matter between the government and these insurgent groups. But what if tomorrow, these Naga groups, they will lay down arms and will join Union of India, will ensure that there is peace in Nagaland. But previously, before this accord, they were terrorists. They had committed crimes. They had committed murders. They had waged war against the country. What if against their leaders, there are cases already pending before the court? Court will not look into whether you have a treaty with the government, whether you have an agreement with the government. Court will look into evidence. Not who you are, but what is the evidence against you. And the evidence against you have waged war against the country. And for that, I will sentence you to death. So the leader of a Naga group who held talks with the government, for example, this leader of the Naga group was sentenced to death. Now he's in jail. And inside the jail, now the government officers, some diplomats, they approach him and say, we will save you. You just have to tell your cadre to lay down arms, join Union of India, sign the ceasefire, sign the treaty, so that from now onwards, you will never claim Nagaland as a separate country or a separate state. This convicted individual, who is the leader of a group, is now signing an agreement in return for pardon. The president will pardon this individual. You are now set free, and not only set free, you are free from all the disqualifications. That means the moment you step out of jail, you can contest the election. You might think this is wrong, but this is diplomacy. This is how you win peace. There has to be an element of give and take. You can't always take and not give anything. These are the reasons why pardoning powers are available with the president or the governor. But what about Tamil Nadu case? Rajiv Gandhi was assassinated. The year was 1991 in Tamil Nadu. Then there was an investigation, and it was found that LTTE, Liberation Tigers of Tamil Eelam, a separatist group in Tamil Nadu, who want a separate country for Tamils in the northern and eastern part of Sri Lanka. Why? Because their language was discriminated. These minorities were discriminated. But then in 1987, Indian Army sent peacekeeping troops to Sri Lanka, which LTTE did not agree. LTTE thought that now Indian government, which had to support us, is now supporting the Sri Lankan government. And they planned this attack, and Rajiv Gandhi, in a suicide mission, was assassinated. And there were many individuals who were arrested. Nalini was arrested. So many other individuals were arrested. Perari Valan was arrested. Now Sonia Gandhi, along with his daughter, they meet Nalini in jail. Nalini, who was one of the convicts in this case, she was pregnant. And then on the recommendation, on the request of Sonia Gandhi, her death sentence was commuted. But that's not the point. The point is undue delay in disposing mercy petition. What is this undue delay? I am convicted by the court. I approach the President of India. Please grant me mercy. Please accept my mercy petition. I send this matter as the President to the Union Cabinet. Union Cabinet, even if it gives advice or does not give advice, but I am not acting on this mercy petition. That means this mercy petition is pending. The killers of Byan Singh, the Chief Minister of Punjab, mercy petition pending. Rajauna, mercy petition pending. So many mercy petitions were pending. Then Afzal Guru's mercy petition was pending. Afzal Guru, who was convicted in Parliament attack case of 2001, he filed a mercy petition in 2006 and it was pending. The BJP, which was in the opposition at that time, accused the Congress of being soft on terror. That is why you are not hanging Afzal Guru, despite the fact that Supreme Court has convicted him. Why are you saving him? Why don't you reject his mercy petition? The government said Afzal Guru's mercy petition is at a different serial number. First, we have to dispose of other petitions which are pending. Then Afzal Guru's case will come up. Then came 26/11 attacks on Mumbai. Ajmal Amir Kasab was arrested, alive, and then he was prosecuted. He was sentenced to death. He also filed mercy petition. But his mercy petition was rejected by the then President of India, Pranab Mukherjee, on the advice of the cabinet, and he was hanged. Then the BJP said, how come now Ajmal Kasab, who was last on the list of the mercy petition, suddenly he is hanged, but Afzal Guru is safe? Then in February 2013, Afzal Guru was also hanged. But when he was hanged in secrecy. That means after his hanging, his family was involved. His family was informed. Media was informed. Matter went to the court. Shatrughan Singh Chauhan versus Union of India, 2014. And it was this judgment which humanized death penalty. Humanized in the sense, number one, informed family 14 days before hanging. Gave opportunity to the family to meet convict. Those suffering from mental illness shall not be hanged. And wherever there is inordinate delay in disposing of mercy petitions, commutation will take place. Supreme Court in 2014 in Shatrughan Singh Chauhan versus Union of India said, if there is a convict who is suffering from mental illness, schizophrenia, for example, this person cannot be hanged. Whenever you have to hang an individual, give him the opportunity, give him a notice, and after 14 days, you can hang this individual. Because in this 14-day period, he will make peace with his God. Maybe he want to apologize to God or some other individuals. He want to seek penance for what he has done. Within this 14-day period, you have to inform his family as well and set up a meeting of this convict with the family so that he can bid them a final goodbye. And that is how, after 14-day period, you can hang this convict. But if there's an inordinate delay means delay which you can't explain. Why this delay? Why are you late for the class? There was traffic. Oh, you're from Bangalore. Except, why are you late? The class is in a village. There's no traffic. You can't explain why you are late. Inordinate delay. If the mercy petition is filed before the president, but there's a delay in disposing of this mercy petition, the president is not saying mercy petition is accepted or rejected, and he's not able to explain also why there's delay, then this death sentence will be commuted to life imprisonment. In Tamil Nadu case, when these individuals were arrested, when they were sentenced to death, after that the Supreme Court had commuted their death sentence. That means now they are not death sentence convicts, they are under life imprisonment. Chief Minister and Cabinet of Tamil Nadu is advising the governor to set convict free in the Rajiv Gandhi case. When your death sentence has been commuted to life imprisonment, that means now this individual is under life imprisonment. Can governor commute life imprisonment? Yes. Can governor pardon a life sentence? Yes. That means if you are under life imprisonment and if you are under death sentence, can governor pardon a death sentence? No. Can governor pardon a life imprisonment? Yes. Which means you will be set free. Chief Minister and the Cabinet of Tamil Nadu advising the governor, please set Parari Balan and others free. Governor says, I will not do it. Why? Number one, this convict was booked under the central law. So there was an investigation done by the central agency. So if at all he is to be set free or not, for that I will have to take the advice of the president. I have to reserve this matter to the consideration of the president because this individual was convicted under a central law and this individual was investigated by a central agency. Question number two. For example, there is a convict who is sentenced for a crime for which death sentence is an option. But this convict was given life imprisonment. For example, I have waged war against the country, for which what is the maximum sentence? Death. But when my matter reached the court did not grant me death sentence, did not grant me the maximum punishment which was available under this offense, but instead granted me life imprisonment. That means for this crime, death sentence was an option, but death sentence was not given, life imprisonment was given. According to Criminal Procedure Code, unless and until I serve mandatory 14 years, I am not available and eligible for remission. What does that mean? What is life imprisonment normally? Sometimes the court says, for you, you will remain in jail for the normal life of an individual, which means throughout your life, you will remain in jail, you will never be set free. Or if you are told that you are given life imprisonment, but that does not mean you will remain in jail forever if it is not for the normal life of an individual. If it's a simple life imprisonment, after 14 years, there will be a committee set up in the jail. Here is a convict, he was awarded life imprisonment. Not the life imprisonment for his entire life, but simple life imprisonment. And then he is in jail, he is in prison. Once he serves 14 years, there will be a committee set up, the prison committee, and they will look at his condition. They will look at his conduct throughout these years. And if they feel that he is good, he has reformed, because jails, prisons are after all for your reform. That's the golden rule of a criminal justice system. Criminal justice system's goal is to give punishment so that it can deter others from committing crime. And give punishment so that you can reform this individual. Your parents are giving you punishment, but not because they hate you, because they want to reform you if you have done something wrong. So if this individual was in the jail for 14 years, he was given life imprisonment, but after 14 years, there will be a review. Whether this individual has reformed or not, whether he is doing good or not, whether he can be an asset to the society or not, whether if we set him free, whether he will be able to live the life of a normal individual or not. If yes, we will remit his crime, we will remit his sentence, we will release him. But previously, Criminal Procedure Code said, if you were given life imprisonment, unless and until you mandatorily serve 14 years, you will not be eligible for early release. That's what we call remission. You will not be eligible for early release. In Tamil Nadu case, there were individuals who were given life imprisonment for crimes for which death sentence was an option. The governor of Tamil Nadu said, I cannot release these individuals because I cannot pardon a death sentence. Chief Minister and his cabinet is saying, but you are not pardoning because they were not given death sentence. So this is not a death sentence case. Governor said, no, matter went to the Supreme Court finally. And Supreme Court said, under Article 161 of the Constitution, the governor has the power, only on the advice of the cabinet of that state, Chief Minister and his cabinet, that you can pardon an individual who was convicted for a crime for which he was not given death sentence, but death sentence was an option. Instead, he was given life imprisonment. You don't have to necessarily serve 14 years after which only you can be released. You can be released even before serving these 14 years. That means if you are an individual who has been convicted for a crime for which death sentence was an option, but you were not given death sentence, you were given life imprisonment. For that, you don't have to mandatorily serve 14 years in jail, after which you can be released. You can be pardoned at any point in time by the governor under Article 161 of the Constitution, only on the advice of the Chief Minister and cabinet. And that is how newspapers misleadingly wrote the headline, Governor can now pardon a death sentence. Governor can pardon a convict who was convicted for a crime for which death sentence was an option, but was not given. Instead, life imprisonment was given. And without serving mandatory 14 years, you can be pardoned. That is the position of the Supreme Court on Tamil Nadu case. And that is how later on Parari Balan and others were released. That is the pardoning power of the president and the governor under Article 72 and 161. Can governor commute a death sentence? Yes. Sir, I can't see previous videos. Maybe there is a technical glitch. We have received some complaints from the students as well. But today, we will be able to sort this out. Please don't worry. Recordings have not disappeared. There is some technical issue. We are working on it. We will resolve it. And you will be given access to those recordings again. Please do not worry. Okay. Now, let's look at prelims-based questions one by one. This question was asked in 2017. Local self-government can be best explained as an exercise in 3 seconds to go. Laksh previously used to be at rank 1, but now maybe has taken extra time to answer. Local self-government can be best explained as an exercise in democratic decentralization. Balwant Rai Ji Mehta recommended in 1958 that there should be democratic decentralization. That means create a 3-tier structure in local government and empower them with powers so that these institutions emerge as the units of rural local self-government. So local self-government is an exercise not of federalism, not of administrative delegation, because this delegation is not given by administration. In fact, it's distribution of powers, not delegation. Not direct democracy, because not all people are participating in these exercises, but democratic decentralization. 2016. The minimum age prescribed for any person to be a member of Panchayat is 25. Panchayat reconstituted after premature dissolution continues only for the remainder period. Okay. 57% students are right. The minimum age prescribed for any person to be a member of Panchayat is 25 years. If you are qualified to contest legislative assembly elections, you are qualified to contest Panchayat elections as well, with one difference: age. If you are 21 years old, you can contest Panchayati Raj elections. That means this statement is incorrect. The Panchayat reconstituted after the premature dissolution continues only for the remainder period. Correct? Because the term of the Panchayat is 5 years. If it is dissolved prematurely, which means let's say after 1 year, and then fresh election is conducted, this new Panchayat which was constituted will remain for the remainder of the period. Correct? So which of the statements are correct? B, 2 only. This question was asked in 2019. With reference to the Constitution of India, consider the following statements. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution of India cannot be called into question by the Supreme Court. Which of these statements are correct? Take the answer. Why are you not attempting these questions? Even if you are wrong, but please attempt. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Incorrect. Because I told you, High Courts can hear all kinds of cases. Fundamental rights violation cases, constitutional cases, challenge to the central laws. Any case can be heard by the High Court. An amendment to the Constitution cannot be called into question by the Supreme Court. This you would know is incorrect. Because a constitutional amendment is challenged before the Supreme Court. 99 Constitutional Amendment Act, NJAC, was declared unconstitutional by the judiciary. Recent amendment, 103rd Amendment to the Constitution. It was challenged before the court, EWS reservation. So constitutional amendments are called into question by the Supreme Court. Neither 1 nor 2 is the right answer. This question was asked in 2019. With reference to the Constitution of India, prohibition or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? The decisions taken by Election Commission while discharging the duties cannot be challenged in any court of law. The Supreme Court of India is not constrained in the exercise of its powers made by laws passed by the Parliament. In the event of grave financial crisis, the President can declare financial emergency. State legislatures cannot make laws on certain matters without the concurrence of the state or the union government. What is the right answer? Why are students confused between A and C? Under Article 142, Supreme Court can give any order so as to give complete justice. So even if you do not remember what is this complete justice, you at least will have to remember that Article 142, when we discussed in the class, sir, talked about judiciary. So it is not about Election Commission. It's not about financial emergency. It is not about state legislatures cannot make a law. It is about Supreme Court. Supreme Court is not constrained. It's not limited by the power, by the laws passed by the Parliament. It can do anything so as to give complete justice. That's Article 142. Sir, why aren't the previous accessible? My dear, I told you previously, there is some technical issue, some technical glitch. We are working on this. Will be resolved today, hopefully. You will regain access to those classes. Don't worry. Okay. Consider the following statements. The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per Judges Inquiry Act 1968. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. The details of the process of impeachment are given under the Judges Inquiry Act 1968. If the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the Parliament and supported by the majority of that house and not by less than 2/3 of the total members of the house present and voting. Which of these statements given above are correct? And I will give you 30 seconds to answer this question. And even if you're wrong, but please attempt it. So Lakshmikant, important chapters. My dear, I can't do two things at the same time. On one hand, discussing previous year's questions, and on the other hand, discussing the important chapters of Lakshmikant. We will discuss these previous year's question papers, then we will jump to the important chapters of Lakshmikant. Patience is a virtue. This is our leaderboard. The motion to impeach a judge of the Supreme Court, sir, you said we use the term impeachment only for the President of India. Then why is UPSC using this term for the judge of the Supreme Court? UPSC is wrong. And UPSC has made mistakes in some of its questions in the past. It will make mistakes tomorrow as well. So hold UPSC accountable, not me. I have to tell you the real picture. Impeachment is a term used only and only for the President by the Constitution. The motion to impeach a judge of the Supreme Court cannot be rejected. It can be. Justice Deepak Misra case. Motion was sent by the Rajya Sabha MPs to the chairperson, the speaker of the presiding officer of the Rajya Sabha. He rejected it. So it can be rejected. The Constitution of India defines and gives details. Constitution only says the judge of the Supreme Court and High Court. can be removed by the president on the recommendations of the parliament when the parliament passes a resolution by two-thirds of the members present and voting and by majority of the total membership of the house on the grounds of proved misbehavior and incapacity. But what is this proved misbehavior? What is this incapacity? It is not defined in the constitution. For that, we have a law passed by the parliament known as the Judges Inquiry Act of 1968. The details of the process of impeachment of the judges are given in Judges Inquiry Act, correct? Process is not mentioned in the constitution. Is it mentioned in the constitution? No. Where is it mentioned? Judges Inquiry Act. That means if you are from Rajya Sabha, 50 MPs will have to write to the chairperson. If you are from Lok Sabha, 100 MPs will have to write to the speaker. Then if the speaker accepts, there will be a three-member committee. Three-member committee will submit a report. Judge will be given an opportunity to present his side of the story. This entire process is mentioned under Judges Inquiry Act. And once basis this report, when this motion is to be taken up for voting, if both Lok Sabha and Rajya Sabha pass a resolution by majority of the total membership of the House, which is absolute majority, and by not less than two-thirds of the members present and voting, the judge is removed. So 3 and 4, C is the right answer. 2017 question. In India, judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, the power of the judiciary to question the wisdom of the laws enacted by the legislatures, the power of the judiciary to review all enactments before they are assented to by the president, the power of the judiciary to review its own judgments given earlier in similar or different cases. 30 seconds. Tell me what is the right answer. So please assure us that previous live classes will be viewed. 100%, my dear. Otherwise, we would not have started this initiative. Why would we do that? Don't worry. 46% students. In India, judicial review implies what? Is it power? And whenever you are confused about options, first eliminate the wrong ones. The power of judiciary to review all legislative enactments before they are assented to by the president? No. There have been instances where people have approached the judiciary even before the laws were passed by the parliament, saying these laws are unconstitutional. This bill is unconstitutional. The Supreme Court has said you cannot question the validity of a bill inside the judiciary. You can question the validity of a law. That means we don't know whether this bill will be passed by the parliament or not, then signed by the president or not. So you are talking about hypothetical situation. This bill is unconstitutional. This is a hypothetical situation. What if bill is changed by the parliament, not signed by the president? We are wasting our time. First, let the bill be passed, then signed by the president. Once signed by the president, you can approach us challenging the validity of this law. So not before they are assented to by the president, after they are assented by the president. The power of judiciary to question the wisdom of the laws, that's not what judicial review is. You cannot question the wisdom of the parliament. The power of judiciary to review its own judgment. Yes, that is review judgment. That is the revisory jurisdiction of the court. That's the power of the court. But in reality, if the question is asking you in India, what does it mean? And if there are two statements which it appears are correct, you have to pick the most appropriate answer. And the most appropriate answer is power of the judiciary to pronounce upon the constitutionality of the laws as well as executive actions. 122 2G licenses cancelled, judicial review. NJAC, unconstitutional, judicial review. So legislature actions as well as executive actions. That's what judicial review is. And that is why A is the right answer. 2014, and this has to be correct. If you will not mark this question correct, I'm leaving. The power to increase the number of judges in the Supreme Court of India is vested in Sir, but due process of law includes questioning wisdom of the parliament. It's not basically questioning the wisdom of the parliament. It's basically questioning the fairness of the law. The law has to be fair. The procedures have to be reasonable without getting into the intention of the law. Although in due process of law, court can even do that. But we don't say it explicitly. We say we follow procedure established by law, which also includes that laws have to be fair. I was knowing this even then. Some of the students are wrong. The power to increase the number of judges in the High Court is given to the president. Every High Court will consist of Chief Justice and as many judges as determined by the president. Power to increase the number of judges is given to the Parliament. The Parliament has increased the number of judges, and this is something we discussed explicitly. Parliament can enact an ordinary law to increase the number of judges. That is how today we have a Chief Justice and 33 other judges. And I told you this law shall not be deemed as amendment to the Constitution. That means although you are amending the Constitution, but you are doing this to an ordinary law by simple majority. So even if you are confused, you should still go back to these lectures in your mind. Well, by discussing increasing the number of judges or judges appointment, Dick Sir said something about President of the Parliament. Okay, 2014, the power. Now this is as easy as it can get. 15 seconds. The power of the Supreme Court of India to decide disputes between the centre and the states falls under its advisory, appellate, original, writ. Original jurisdiction. The Supreme Court has original jurisdiction in cases which are federal in character, involving disputes between the centre and the states. This is the easiest question ever asked in the history of UPSC exam. Please, patience. Read the question carefully. Mark it correctly. Correctly in the sense, read it. Understand it. Then mark it. But sir, you are giving 15 seconds only because this is the easiest question. Okay, now let's see what you will do here. Right to vote, I will increase the time. Right to vote and to be elected in India is a fundamental, natural, constitutional, legal right. My God. 10% students say A. When did I say right to vote is a fundamental right? Is it under Part 3 of the Constitution? Right to vote, my dear, Article 326. Where is it mentioned under Part 3 of the Constitution? So it is clearly not a fundamental right. It's not a natural right under Article 19, because all the rights under Article 19 are natural rights. It is a legal right provided by the Constitution. But the most appropriate answer is that it's a constitutional right under Article 326. Okay. In an election for the Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared winner. According to the provisions laid down in the Constitution of India, in Lok Sabha, the Speaker's post goes to the majority party and the deputy speakers to the option. Which of the statements given above are correct? And for this, I will give you 1 minute. Sir, in Google, it shows that motion to impeach a judge of Supreme Court cannot be rejected. Well, Google in that case is wrong, but it should not be Google. Google only gives you searches. Check the website which has given that information. That website is wrong. Even if multiple websites display that information, that doesn't change the fact that they are wrong. And I've given you explanation as well. Just as Deepak missed out, the motion to remove him was rejected. Okay, 63% students are right. Laksh again is top. His Laksh is clear. In the election for Lok Sabha or State Assembly, winning candidate must get at least 50%. But we follow first past the post system, where you don't necessarily have to get the majority. You just need to get the highest number of votes. Incorrect. According to the provisions laid down in the Constitution, no. This is a convention, unwritten rule, something that is decided by political parties themselves, that the Speaker's post will be given to the ruling party or the ruling coalition, and the deputy speakers will go to the opposition. But this is not mentioned in the Constitution. Constitution only says that after the Lok Sabha is convened, as soon as maybe, the House shall elect 2 of its members as the Speaker and the Deputy Speaker. It does not say the Speaker has to be from the ruling party and the Deputy Speaker from the opposition. So both these statements are incorrect. Neither 1 nor 2 is the right answer. 2016, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by Lok Sabha by simple majority, Lok Sabha by 2/3 majority, Rajya Sabha by simple majority, Rajya Sabha by 2/3 majority. Such a simple question, which I'm sure is not simple for you. 20, 30, 40, 46, 52, 55% students are wrong. Parliament of India acquires the power to legislate on any item in the state list. We are talking about Article 249, which I told you is one of the special powers of the Rajya Sabha, where only if Rajya Sabha passes a resolution by the majority of not less than 2/3 of the members present and voting, only then Parliament can legislate on any item in the state list in national interest. So D is the right answer. Question number, and this question was asked in 2019. Which one of the following suggested that the governor should be an eminent person from the outside of the state and should be a detached figure without intense political links or should not have taken part in politics in the recent past? Was it the first Administrative Reforms Commission, Rajamana Commission, Sarkaria Commission, National Commission to review the working of the Constitution? Simple question, 15 seconds, tell me the right answer. It is the chairperson of Rajya Sabha who rejected Justice Deepak Mishra's case, right? But under the Constitution, and we have discussed that if you have attended the class, Judges Inquiry Act says the presiding officer may accept or reject that petition. Presiding officer includes Speaker. 76% students are right. It is the Sarkaria Commission of 1983. Very good. This question was asked in 2021. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. Whenever you read such statements, underline the important points. In India, there is no law restricting the candidates in one Lok Sabha election from 3 constituencies. In 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. As per the existing rule, if a candidate contests in one Lok Sabha election from many constituencies, his party should bear the cost of by-elections to the constituencies vacated by him in the event of him winning in all the constituencies. Which of the given statements above are correct? I will give you 1 minute to answer this question. See if you can eliminate some options, and even if you don't know the statement whether it is correct or incorrect, maybe you can eliminate some options and reach to a conclusion. Ten seconds to go. Yes, Laksh, mostly extreme statements are wrong. 49% students are right. Let's see. In India, there is no law restricting the candidates from contesting in Lok Sabha election from 3 constituencies. Incorrect. There is a law. What is that law? Representation of the People Act 1951. Yesterday we discussed one electoral reform. That today, Representation of the People Act allows a candidate to contest election from up to 2 constituencies. And the reform we proposed was that candidates should be allowed to contest election from only 1 constituency, not up to 2. So first statement is clearly wrong. Second statement, I don't know. As a student, you would say, I don't know. How can I remember all of this? Devilal, whether he contested from 3 or 6, how do I know? Let's leave it. And please understand, whenever such statements are given in the question, you should assume that UPSC is trying to mislead you. Even if you don't know the answer to this question, even if you don't know whether the statement is correct or incorrect, it is immaterial, you can still give the right answer. You don't need to know whether the statement is correct or not. You can still give the right answer. Play with UPSC. How? As per the existing rules, if a candidate incorrect, clearly incorrect. Why? Mr. Modi contested from Vadodara as well as Varanasi. And then after the election, he had to give up 1 seat. He gave up Vadodara. That means fresh election was to be conducted here. But political parties do not bear the cost of re-election or by-election. And I told you the very reason why we are saying that candidates should be allowed to contest from only 1 constituency is that it is like harassing the voter. to vote again in the same constituency. And it wastes a lot of time. That means same amount of money is to be spent again. This is public money. Political parties do not contribute for by-election. So this statement is clearly incorrect. So 1 and 3 is clearly incorrect. This cannot be the option. This cannot be the option. This cannot be the option. So the only answer left is B. 2 only. But sir, isn't it contradictory? You said representation of the people Act says that you can contest election from only up to 2 constituencies. And now how can Devi Lal contest election from 3 constituencies? This is in 1991. The law was amended in 1996. But sir, how do I remember whether this law was amended in 96 or not, before 91 or not? At least you can eliminate 1 and 3. Both these things we have discussed. 1 and 3 is wrong. That means the only other option is left is 2. B only. B is the right answer. Okay. This question was asked in 2015. The Legislative Council of a state in India can be larger in size than half of the Legislative Assembly of that particular state. The governor of a state nominates the chairman of the Legislative Council of that particular state. Which of the statements given above are correct? 30 seconds. What's the right answer? Since BSP nowadays neither gets seats nor votes, then why its national party status has not been struck down? It does get votes, but those votes do not translate into seats. And it has a presence in Chhattisgarh, in Madhya Pradesh, in Rajasthan. In Rajasthan, they had 6 MLAs. But it's another question that all these 6 MLAs joined the Congress. 54% students are right. Laksh continues to have his Laksh. Clear. Legislative Council of a state can be larger in size than 1/3 of the Legislative Assembly, not half. So this is incorrect. The governor of a state nominates the chairman. No, this person is elected from amongst the MLCs. All the MLCs, they will get together, elect the chairperson and deputy chairperson by simple majority. And they can be removed by effective majority as well. That's something that we have discussed. So D, neither 1 nor 2 is the right answer. 2014, which of the following are the discretionary powers given to the governor? There shall be Council of Ministers, the Chief Minister at the head to aid and advise the governor, who shall act on their advice except when the governor has to act in his discretion. But these discretionary powers are not mentioned in the Constitution. But then which are these discretionary powers? Sending a report to the President for imposing the President's rule, appointing the ministers, reserving certain bills passed by the state legislature for the consideration of the President, making the rules to conduct the business of the state. Please attempt, all of you, even if you're wrong, but attempt. Seconds to go. Manpreet, what's your question? 68% students are right. Okay. Will governor send a report to the president telling the president, please dismiss the government and impose president's rule in the state on the advice of the chief minister? No. So this has to be discretionary power of the governor. Appointing of ministers. Appointing a chief minister is a discretionary power. But all ministers are appointed by the governor only on the advice of the chief minister. So this is incorrect. Reserving bills passed by state legislature for consideration of the president of India. What is the matter between the governor of Telangana and the government of Telangana? Same is the case in Tamil Nadu. Same is the case in Punjab. If you read today's Indian Express newspaper on page number 1, you will see that Supreme Court is saying that only when the matter reaches the court, that is when the governor decides to take action on a bill. The governor should decide on these bills before these matters reach to the court. The governor will have to do some soul searching. That's what Supreme Court said. Soul searching, because you are not elected by the people. One point of contention between the government and the governor is that you are reserving bills for the consideration of the president. That is the discretionary. Otherwise, why would a chief minister ask the governor reserve this bill for the consideration of the president? So this is a discretionary power. Making rules to conduct business of the state government, this is not the discretionary power. How the business is conducted, how many ministries are to be created, who gets to be allocated portfolio of a particular department, that is not the discretionary power of the governor. That is under the advice of the chief minister and council of ministers. So which of the statements are correct? 1 and 3. B is the right answer. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, we are talking about President's rule under Article 356, then the assembly of that state is automatically dissolved. The powers of the legislature of that state shall be exercisable by or under the authority of the parliament. Article 19 is suspended in that state. The president can make laws relating to that state. Simple question, 30 seconds for you. What is the right answer? Laksh, we will be starting prelims test series in December. So take those tests. And you can also find lots of MCQs on the app. Practice more. QT is at 160. If the President of India exercises his power as provided under Article 356 of the Constitution, then assembly of that state is automatically dissolved. What did I tell you about SR Bombay judgment? That president's rule, when it is invoked in a state, the Supreme Court has said don't dissolve the legislative assembly unless and until both houses of the state parliament approve this president's rule. Even if you have not read this, look at the reality, look at current affairs, try and find out answers from the newspaper reading. Where was president's rule imposed recently? Maharashtra. Why? Because Shiv Sena, BJP, they parted ways, they could not form the government. No government was possible, president's rule was imposed. But then this president's rule was also revoked. Did a fresh election take place? No. That means if there was no fresh election, that means the same legislature continued. Which means legislative assembly is not automatically dissolved. It is kept under suspended animation. It is suspended. And when these MLAs, they are able to form the government, then this assembly is revived. And from this assembly, we choose the chief minister and the ministers and they continue. It is only when no government is possible, then the governor has no other option but to dissolve the legislative assembly. But it is not automatically dissolved. It's not that as soon as you impose president's rule, legislative assembly is dissolved. No. As soon as you impose president's rule, chief minister is dismissed. Council of ministers are gone. Not the legislative assembly. Incorrect. Article 19 is suspended in that state. Article 19 has nothing to do with president's rule. Article 19's enforcement is suspended automatically when national emergency on the grounds of war or external aggression is imposed. Fundamental rights have no bearing when it comes to president's rule. The president can make laws relating to that state, but president is a part of the executive. How can he make laws for that state? No. Article 356 says when the president proclaims president's rule. In its presidential proclamation, it says all the executive powers of the state will be with me, I'm the president. All the legislative powers will be with the parliament. That's how during president's rule, parliament makes laws for that state. When national emergency is imposed, then is the state assembly automatically dissolved? No. And we discussed that during national emergency, in fact, the life of the legislative assembly is extended 1 year at a time. Okay. 2017, which of the following are not necessarily the consequences of the proclamation of the president's rule in a state? Not necessarily. That means as soon as president's rule is imposed, these things may not happen necessarily. Dissolution of the state assembly, removal of the council of ministers, dissolution of the local bodies. What is the right answer? Simple question. I'll still give you 30 seconds. My God. 41% students are right. Which of the following are not necessary? As soon as president's rule is imposed, removal of council of ministers in the state, this is necessity. The first casualty is the chief minister and council of ministers are dismissed, removed. But can legislative assembly be dissolved? Not necessarily. And there is no impact of president's rule on local bodies. There's an impact on state government because of president's rule. Panchayati Raj institutions continue. Municipalities continue, even if there is a president's rule. 1 and 3 is the right answer. The provisions in 5th and 6th schedule of the Constitution of India are made in order to protect the interest of scheduled tribes, determine the boundaries between states, determine the powers, authority, and responsibilities of panchayats to protect the interest of all the border states. This is very simple. I'll give you 15 seconds because I've taken 10 seconds to read this question. Wow, 88% students are correct. Very good. To protect the interest of scheduled tribes. 5th schedule deals with states other than Assam, Meghalaya, Mizoram, and Tripura. 6th schedule deals with the tribal areas in Assam, Meghalaya, Mizoram, and Tripura. In essence, what does due process of law mean? 30 seconds. What is the right answer? Do we have to study, memorize objectives of committees and commissions whose recommendations have more or less been accepted and implemented by the government? Or should we study the reports of those committees and commissions whose recommendations are not yet accepted and are pending from a long time? Anything. All the things. Even if there is a committee report which has not been accepted, can be asked in the exam. Which has been accepted, can be asked in the exam. But mostly you should look at those committees which are in the news and focus on them. Oh, Laksh has given a wrong answer, I think, for this particular question. In essence, what does due process of law mean? Does it mean procedure established by law? No. Because under Article 21 of the Constitution, the state shall not deprive an individual of his right to life and personal liberty except according to procedure established by law. But the Supreme Court has said we follow due process of law, which means due process of law is different from procedure established by law. That means B cannot be the answer. B cannot be the answer because it talks about equality before law, and equality before law is under Article 14 of the Constitution, not under Article 21. Now the question is fair application of law or principles of natural justice. Let's say even if we were following procedure established by law, if you have been arrested, Article 21 has been violated, you assume Article 21 has been violated, you will go to the court. How will court set you free? After performing 3 tests. Test number 1, is there a law which justifies your arrest? Test number 2, is this law valid? Test number 3, are the procedures mentioned in the law followed or not? If procedures are not followed, you will be set free. That means if this law is not fairly applied, you will be set free. So procedure established by law includes fair application of law. That means even if we were following procedure established by law, that doesn't mean you can apply this law unfairly. Even there, you have to apply this law fairly. Which means the answer is principle of natural justice. And what is this principle of natural justice? 4th test will be prescribed by the court in due process of law. Is this law reasonable? Are the procedures fair or not? Which means the Supreme Court in its 4th test will look into the intention of the parliament, the wisdom of the parliament, whether it has passed a good law, correct law or not. That is what principle of natural justice is. The authority shall act bona fide. Which means when the legislature is making a law, its intention should be good. It must act in the good faith. So the answer to this question is the principle of natural justice. Okay. Which one of the following statements best reflects the chief purpose of the constitution of a country? It determines the objective for the making of necessary laws. It enables the creation of political offices in the government. It defines and limits the powers of the government. It secures social justice, social equality, social security. 30 seconds. Which one of the following statement reflects the chief purpose of the constitution? What is the role of ad hoc judge? If I have to hear a case, I am the Chief Justice of India. I have to hear a constitutional case, that means involving 5 judges or more. But let's say I have to hear a review for which I need 9 judges. And I can't have 9 judges. I don't have 9 judges. I will appoint an ad hoc judge. 70% students are right. What is constitutionalism? Government should and must be restrained in its powers. And the legitimacy of the government depends upon whether it is observing those limitations or not.